But before I say that, do we have any apologies for absence, Mrs. Beckford?
No apologies, Chairman.
Okay, very well. I don't have any extensive opening remarks this afternoon, colleagues. Suffice it to say, we have had extensive submissions from both public and private stakeholders. We are in the process, the parliamentary secretariat is in the process now of putting together or beginning to put together a report. That said, we did have some discussions about holding direct discussions with the particular stakeholders about whom we deliberate in this committee, that is the cohort of older persons. I am still working that through with the Parliament, though they have indicated that they are in support of it and can offer us the support that we need. So we're working out some fine details, and I hope to send an email to committee members to discuss the options and their availability before the end of this week. So by the end of the day tomorrow. That said, we have begun the preparation of wrap up because it's been a lot of information that we've had. We've had, you know, quite extensive deliberations. So the Parliament has begun that preparation, and of course will amend and produce something for us at the appropriate time. That said, we have before us today the confirmation of the minutes for the meeting held on June 13, 2025. That would have been the meeting in which we, in fact, confirmed a number of minutes that have been outstanding. I have read the minutes. I see no corrections that I offer. I assume members have read the minutes as well. And if I am correct, then I would ask one of my members to move for the minutes to be confirmed.
I am so moving, Chair.
Thank you, Senator. Thank you very much, Senator Fraser-Binns. Madam Clerk, for you to note. All right, I am trying to contain my excitement, colleagues, because I am just absolutely thrilled today to have Mrs. Sherry-Ann McGregor visiting the committee and attending to offer her contribution to our process. We have opined in the committee on a number of occasions about the need for some of the legal provisions supporting our older persons to be updated, and we've discussed some of the gaps. But Council is here to talk to us about some of that. She practices in this area, and so I imagine will lend us a wealth of knowledge and assist our process as we move towards the final stages of our committee's work. So I'm going to welcome her and ask her to just introduce herself, tell us a little bit about herself beyond my introduction, and whenever she's ready to go, she can start.
Okay. Thank you, Senator Golden Campbell, for your warm welcome. And I'm grateful for the opportunity to meet with you today. My name is Sherry-Ann McGregor. I'm an attorney at law, a partner in the law firm of Nunes, Goldfield, Dillion & Co. I've been in practice for over 25 years now, and I am also a mediator and arbitrator. I practice extensively in the area of family law, and intersecting with family law are many, many issues to do with estate planning, caring for children, caring for the elderly. And since for about 15 years or so, I've had the opportunity to assist many persons who have come to me with questions concerning caring for their elderly relatives, some of whom are mentally incapacitated. And I've had the privilege of being able to find solutions for them through the courts and otherwise. But in the process of doing that work, I've encountered so many challenges that to say that I'm passionate about what I'm sharing with you today is an understatement. Because the reality is that if we live long enough, we're all going to get old. And all of us have parents, some of whom have passed away, and others of whom we are concerned about how aging has affected them, affected their ability to function. And the question is, do we have effective solutions to help them to ensure that they are not worried about how their affairs will be handled in their later days? I start with a reminder, which I think may have well prompted the work of this committee. The true measure of any society can be found in how it treats its most vulnerable. That's a quote from Mahatma Gandhi. And most times when we talk about vulnerable people, we think about children. But today, I am happy that we are focusing on the elderly. Most times when clients come in to see me and request advice, it's because either they are the people getting older and are saying, how do I pass on some of the responsibility that I have without being overly vulnerable? Because like it or not, there are times when older people pass on the responsibility or share the responsibility with younger relatives, and they are abused. When a client comes in and says, I would love to be able to put my child's name on my certificate of title, but you then have to warn that client that by doing that, they could expose themselves to being homeless, because realistically, somebody else's name on your title means that that person could force the sale of the property. And worse still, if it's an outright gift, when the person owns your asset, then they can do with it as they choose. So the question is, how do you help them? Many times the first port of call is to ask, will a power of attorney suffice? Now, I'm going to assume that many things are already understood by this committee, but I also apologize in advance if some of the things I say amount to repetition of areas that you have covered. Chairman, I'm going to ask you to help me to steer clear of too much repetition. I don't want to bore my audience. And help me to find those areas that you most need my assistance on.
I'm happy to do that, but I would also say to you that while the committee may understand some of the terms, the jargons, and have that background based on the work we've been doing, this is also broadcasted nationally. And there are persons who may just be tuning into the work of the committee today, and there are those who may not understand. So we have no difficulty indulging some amount of repetition for the benefit of our citizens.
Okay. All right. I will still try not to bore you, okay? Because there is so much involved in what we are talking about that I could sit with you and tell you the stories of the experiences I've had for a very, very long time. So I'm going to dial it back and ensure that what I say is pointed and relevant. Let's start with powers of attorney, though, and just appreciating what they are, the scope of them, and how we can go about ensuring that the power of attorney does exactly what we want it to do. And then I'm going to help you to appreciate why where we are as a country right now with respect to powers of attorney is nowhere close to where we need to be. Well before it becomes necessary to have a caregiver or a guardian appointed for an elderly person, the appointment of an agent, or what we call an attorney in fact, under a power of attorney is a viable option for anyone who wishes, for the sake of convenience or through necessity, to have someone else undertake activities on their behalf. It can be simple
Also,
things.
can I just interrupt you one moment?
Sure.
Because I do know that there was a presentation sent to the Parliament. Do you want us to load that?
You
While you're
can.
speaking, or do you?
You can load it because it might help people to follow more easily, but I will be skipping through aspects of it, but I'll let you know when I have to move
Do you
forward.
want to control it then?
I can't do it on this device,
Okay.
but
All
I
right.
think I may be able to direct someone
Okay.
who can
Very well.
share.
Very well.
So-
Mrs. Beckford, can you
Yes.
accommodate that, please?
Okay.
Thank you.
Okay.
So
So
you can
before we
indicate to her,
start,
you can indicate to her where she should start.
okay, all right. Will Mrs. Beckford, will you be sharing the PowerPoint? Chairman, I'm not sure if it's the PowerPoint
Yes, the
presentation.
PowerPoint. Well, which one would you like me to share first?
Share the PowerPoint presentation, and then I'll be able to tell you what slide to go to. Right now, I'm on slide 3. So for the sake of clarity and to explain why I may be skipping over some slides, this presentation was made to the Bar Association last year. And I'm not sure if someone might have heard my cry, because the presentation is entitled "We Should Be Mad, the Mental Health Act is Screaming for Change." So perhaps our thoughts were simply aligned.
Very much so, very much so. This is Senator Longmore.
Oh, wonderful. Good afternoon to you. It's been a while.
Good afternoon, good afternoon.
Okay. So I was explaining what powers of attorney are and how we usually go about getting them signed and the rationale for it. So I'd said already that even before we talk about caregivers or legal guardians for elderly persons, we typically want to figure out, can there be an agent or what we call an attorney in fact, who might be able to help them to get certain things done within reason. Now, powers of attorney date back 2,500 years. So we are not talking about something that is new. And the scope and effectiveness of them that's evolved over time. And powers of attorney may be ordinary, they may be general, covering every single thing you could think of, or they might be specific. So for example, if someone wants to sell a car, but they're living in Montego Bay or living overseas, they may prepare a power of attorney that specifically states that they're asking someone else, who we'll call the donee of the power, to carry out the sale of the car on their behalf. And that would be a specific power of attorney, and it would be for a limited purpose. Now, depending on the needs of the donor, it could be much wider. It might involve the sale of land, or it may involve banking transactions. The important thing to note is that the power of attorney is going to be signed by someone called a donor or principal, appointing someone else called a donee or agent to carry out certain acts. Now, the power of attorney doesn't usually say the date when it comes to an end, but we usually appreciate that the donor will have the right to revoke the power of attorney at any point in time. Now, if powers of attorney have been around for so long, then you immediately ask yourself, isn't there some kind of legislation that governs it? Well, unfortunately, there is none in Jamaica that is specific to powers of attorney. All we have so far is an act called the Probate of Deeds Act, which deals with the execution of deeds. And a power of attorney is what we call a deed. And the reason the reason we say there is no specific law is because in Jamaica, the powers of attorney that we execute all the time are governed by the common law. So although most countries that we often refer to for legislative guidance in Jamaica, such as England, Australia, Canada, they have long enacted specific legislation concerning powers of attorney. We haven't done that. So let's think about what is involved in making a valid power of attorney. That's the 5th slide now. Generally, the power of attorney is valid from the date on which it's registered until the stated end date, or until it is expressly revoked through the execution of a deed, or it might be impliedly revoked. For example, if it's for the sale of a car, then once the car is sold, the power of attorney no longer has effectiveness. Now, a power of attorney is a formal document, it's a legal document, and for it to be valid, it needs to be in writing. It must clearly describe both the donor, the one giving the power, and the donee, the one receiving the power. And the donor must sign it, and it must also be signed by a justice of the peace or other subscribing witness, for example, a notary public if you're overseas. It needs to be dated, and it must outline the powers that are being granted and their duration if necessary. The next step, once the power of attorney is signed, is for it to be stamped at the Inland Revenue Department with the requisite stamp duty paid, and it's not a lot of money. And then it is to be recorded at the Island Records Office at the Registrar General's Department, and the registration fee needs to be paid. Now, quite often, a power of attorney is relied on when a donor is overseas, or for some other reasons, it's not convenient to be present to sign a document. But there needs to be strict adherence to the authority that is given under the power of attorney. So if I give you a power of attorney to sell a car, you can't sell a house. And vice versa, if it says to sell a house, you can't sell a car. So the powers need to be specifically stated. Now, there are various different types of powers of attorney, and this is where I'm going to skip over parts of these because we don't typically see them in Jamaica. Things like a contingent power of attorney. so that it will be triggered if a certain thing occurs. So the power won't vest in the donee until an event has taken place. Or you might have a power of attorney with a flexible end date or an irrevocable power of attorney. But I'm going to skip forward because I need to point out what the strengths and weaknesses of powers of attorney are. And that's on slide 8. Now, the strength of the power of attorney lies in the fact that it's powerful and it's effective and it's a good self-help tool. So you don't need a King's Counsel to give you legal advice as to how to prepare a power of attorney. That's a simple thing to do. And the other strength of it is that it's flexible. You can create a power of attorney for various different actions to take place. I've been mentioning the sale of a car or a house, but it can be banking transactions, various other things. But here's the weakness. The weakness of the power of attorney lies in the fact that there is no statutory framework or guardrail for you to know exactly how it needs to be structured. And that same lack of formality can lead to situations where, on slide 8, can lead to situations where people are manipulated. So someone who is giving power under a power of attorney can easily be told that it's okay to sign a general power of attorney without them fully appreciating that that general power of attorney might be used to carry out acts that they never even contemplated that someone would do for them. And therein lies the problem, because it's usually older people who end up in that situation. There are some interesting cases that I will not bore you with, but I want to explain to you one of the big problems that we've encountered when it comes to powers of attorney. So the first thing you need to appreciate is that a power of attorney can only be signed by someone who is mentally competent to give that power. And once you have signed it when you're mentally competent, you would think, okay, the donee of the power can just go ahead and carry out the acts that are set out in the power of attorney. But the big problem is that, go to slide 11, please. Supervening mental incapacity. I am touching on the fact that when a power of attorney has been signed by someone, they usually want to be able to rely on it, not only when they are able to carry out the activities for themselves, but it might not be convenient for them to do it, but they would love to think that if for some reason they can't get out of bed or their mental capacity becomes diminished, that the power of attorney could be relied on. But unfortunately, that's precisely the time when a power of attorney becomes ineffective. If a power of attorney is signed by a person who has mental capacity at the time of its execution, and some supervening activity, they get older, develop Alzheimer's, or they may meet in a motor vehicle accident or something like that, and they are no longer able to make decisions on their own, then unfortunately, the same power of attorney that you'd hope to be able to rely on becomes legally ineffective. That, I believe, underscores the big problem that we face in Jamaica. We have no legislation governing powers of attorney. We must rely on the common law, and unfortunately, a power of attorney signed by someone with mental capacity who subsequently becomes mentally incapacitated, that power of attorney no longer has legal effect. That's a problem. And the other problem I want to point out is that there are times when, especially as people grow older, the mental capacity diminishes. So they might be very lucid when they wake up in the mornings, and as the day wears on, they seem to become confused and not aware of where they are, who they're speaking with, or generally not aware of the acts that they are carrying out. And so we end up with big questions such as, if you approached an elderly person today and said to them, sign a document that has some legal effect, and tomorrow morning somebody else approaches them and they seem to be confused, seem to be incapable of making decisions, then it gives rise to the question, at the time they signed the legal document yesterday, was it a lucid interval? And those questions have dogged courts for generations, because it is very difficult to be able to say definitively that at the time the person signed the document, that they were mentally competent to do so. And let me just say, I welcome and invite any feedback or questions as I go along, because I don't want to treat this as if it's simply a lecture. Okay?
And
Chairman?
now on that invitation, Council, could you speak a little bit to what kinds of evidence has persuaded the court from circumstance to circumstance that a person was having a lucid interval? How do you define that moment for the court? Because certainly, and I'm sure Senator Longmore can speak even more to this, my experience of older persons who are having reduced cognitive capacity, it's not a straight line. There are days of perfect lucidity and the person is back as you knew them. And then there are days of deep emotional distress, and their connection to reality may not be quite as strong.
Yes.
So how do you what have the courts allowed to be convinced that in a moment the person was lucid?
So it's a mixed bag, right? The first and obvious type of evidence would be that of the common observer. So if I'm the caregiver or the relative of an elderly person, then if I'm in close contact with them from day to day, then I'm in a position to say how they progress through the days and how they respond to certain things, how they relate to their environment. You might have woken up this morning and watched the news and commented on what was said in the news. So in time and space, you were quite coherent. You might have fed yourself that morning or specifically asked for breakfast. So those are just clear observations and matters of fact. But then, of course, there is the medical evidence, which is critical to a court's ability to analyze lucidity. And that's where someone like Dr. Longmore would come into the picture. And unfortunately, what I've experienced over time is that many people who simply get this precipitous decline in mental competence and coherency, they had not been seeing medical practitioners with regularity over the years. So when they get to that point where there are questions about whether what they are doing is generally in keeping with the actions of someone who is in control of their faculties, then it becomes harder because you have no baselines from which to determine whether the decline has occurred. But the medical evidence coupled with the general evidence from typical observers is what a court would accept to determine whether or not lucidity existed at the time a specific act was carried out. I don't know if Dr. Longmore wanted to comment. No?
Hi, Chair. Hi. I just put my camera on. My apologies. The meeting time coincides with my other duties. Yes, the real reality is that, and this is what we're seeking to address, where the level of continuous monitoring after a certain age is not the typical norm that exists. And yes, there are objective tests that we use, particularly, well, I won't go into the technical details of it. The mini mental status exam is one that comes to mind, but there are also other very detailed cognitive assessments that we do. But the issue is that these circumstances, the decline doesn't necessarily occur immediately in the moment that the pathology is noticed. And so the level of monitoring has to be almost preemptive, has to be based on family history, etc. And if a caregiver is particularly keen on picking up on the slow deteriorations. And so, we could, my dear, it is not, you're not the one who would need to give a fulsome lecture here. I would join in. There are many ramifications to this and many considerations that has to happen. And I would not want to put that into the details of the committee at this point in time. Needless to say that I will be available after this or at another time when I can fulsomely bring this to the technicalities that might be involved. But ditto to the fact that the Mental Health Act significantly needs to be reviewed, to be addressing especially issues such as this.
Thank you,
Absolutely.
Senator Longmore. Councillor, I would just ask you too, as you are discussing the various points, if you could indicate to us what, in a sort of broad way, is a legislative fix. So in terms of this situation now, we're talking about how a court assesses lucidity in the moment. Is there a legislative provision? Is there something we can do in statute that assists that process? I know it is particularly heavily medical, but how do we as a committee, in terms of looking at a law that is going to address some of these issues, how do we treat with that? Right.
Somebody
Chair,
else.
If I may, Chair, that is the nature of how how vast and how complex it is. The legislation, dare I say, cannot go forward without the medical consideration. So what has to happen is that level of knowledge of what is medically required for the law to suit it, which is why I said that is almost like a special meeting that has to be had for us to be able to fulsomely address the issue.
I'm not sure that is something that would need to sit with this committee. That sounds like something far more detailed in terms of how you're drafting. But my question to council was, is this, whatever it is that would be the ingredients of that, is this something that you would recommend be enshrined in law in terms of the type of evidence, that kind of thing, that the court should be mindful of in making its decision? We've done that in many statutes. The kind of things the court must look at to guide the court in terms of assessing. So that really was my question.
Right. So here's how I'd love to answer your question. I started out by referring to powers of attorney and how useful they are, and pointing out that we have absolutely no legislation governing their structure or use or anything like that. So that's one of the first things we need. Some kind of statute that tells you what a power of attorney should look like and what will be acceptable in law. That's number one. And number two now is recognizing that even when you have a piece of legislation dealing with powers of attorney, you need to put in place proper solutions to deal with those times when a power of attorney alone will not suffice. And you have to assess whether the person is still mentally competent to give power. So that's where I looked not just at what our deficiencies are, but what other countries did in terms of providing solutions. And that takes me to slide 14, which are some interim observations that I made. The first one, as I said, I cannot explain why we have no legislation while other jurisdictions have had powers of attorney acts for more than 50 years. And then I say, although powers of attorney are useful and reliable, they do not provide solutions for mentally incapacitated persons, particularly for donors who validly executed powers of attorney, but have now had supervening mental incapacity. And then I'm pointing out that from a legislative standpoint, there are reasonable and practical solutions within reach, which we have failed to utilize to ensure that valid powers of attorney can outlast the supervening mental incapacity of a donor. So, Chairman, in other words, what I'm saying is what we need to do is to empower those persons who are still mentally competent so that when they put solutions in place so that somebody can carry out actions on their behalf, that person's power continues to be effective even if the donor becomes mentally incapacitated. So that's where we are talking about powers of attorney that endure past the point of mental incapacity. So we will no longer be talking about whether somebody has had a lucid interval. Are you with me, Chairman?
I'm with you. I am with you.
Because the question about that lucid interval is so nuanced and so difficult to answer that what we are aiming for is a situation where we say to people, while you are mentally competent, put measures in place so that we don't have to answer questions about whether you are competent anymore. The court still has the jurisdiction to question and investigate those things. But just like when we're talking about estate planning, and we say to people, do it now, so that we are not talking about having the courts determine how your assets are to be shared among your beneficiaries. What we are saying is, let's empower people by having legislative support for them to put measures in place that outlast mental incapacity. Clear?
Miss McGregor?
Yes?
In another way, that is exactly what I just said.
Okay. All right.
Council, is there a difference? The solution you're proposing is that not the structure of the living will?
It may be an
in
aspect
the
of
UK?
it.
Mhm.
It may be an aspect of it. But I was just about to touch on England's response
Go ahead, please.
to help us to see how their position has evolved over time, so that we aren't repeating some of the, I don't want to call them mistakes, but we are not covering ground they have already covered, found to be inadequate, and taken measures to make more effective. We can go all the way to the point they're now at. Where relevant, we can look back for sure, but their most recent change was 2023. So we don't have to go back to 2007, 1985, where it started. But here's the slide on England now. This is slide 15. And I started out by saying that while I'm not advancing that the position in England is a perfect example, their legislators have been either active or proactive in addressing powers of attorney and mental health issues. So we have some benchmarks to look at. In England, the first solution to address what I'm calling supervening mental incapacity. So you are fine today and your mental incapacity emerges tomorrow or over the next several years. What we're saying is that the solution to that is that the donor under the power of attorney was given what we called enduring powers of attorney. And that was in 1985. And the description of the legislation was enough to tell you what they were trying to do. It said it was an act to enable powers of attorney to be created, which will survive any subsequent mental incapacity of the donor, and to make provision in connection with such powers. Now I'm thinking that makes a lot of sense. Over the years, though, they discovered that there were deficiencies in the statute, and they acknowledged and addressed them. And then, effective October 1, 2007, they repealed what the Enduring Powers of Attorney Act, and the new expanded power called a lasting power of attorney was introduced. It replaced the enduring power of attorney, and they incorporated all of that into the Mental Capacity Act. Now, the amendment went well beyond merely changing the word. So under the Mental Capacity Act, in the next slide, this is, okay. Under the Mental Capacity Act, here are a few things that they did. They made sure there was no need to apply to the court. right? That what you created was a lasting power of attorney that could be registered with a body they call the Office of the Public Guardian. And that office could investigate allegations of abuse of power. And they created under it 2 forms of lasting powers of attorney. One that dealt with property and financial matters, and the other with health and welfare. And they then amended the Power of Attorney. It was amended by the Power of Attorney Act in 2023 to simplify the registration process. And I pause here for a second, Chairman, because one of the things that we recognized was that where a power of attorney was no longer effective because someone had become mentally incompetent, we had to rely on the Mental Health Act, which I will touch on in a few minutes. And under the Mental Health Act, to appoint the equivalent of an agent or a donee, who we call a guardian under that act, could be a tedious, time-consuming process, and certainly a costly one that many persons who required an agent or a guardian simply could not afford. So having something in place that would help us to avoid the necessity of going to court to resolve these issues would also be ideal. So I say here, there is a gap that needs to be filled. We move from the point where a power of attorney is effective, get to that place where it's no longer effective because the person has become mentally incompetent. They become mentally incompetent, the power of attorney goes away. There is no enduring or lasting power of attorney. The only option available at that point is to apply to the court under the Mental Health Act. That's the gap we need to fill. Down to the next slide.
As you're doing that, counsel, I just want to underscore what you're saying, because that requirement to go to court requires medical evidence. And
Yes.
Part of the problem, I certainly have seen it in my own practice, is that depending on the type of issue that the older person faces, you may or may not be able to get them to a doctor.
Mm-hmm.
Because you may have somebody who is physically strong and physically well, and if they are not going to a doctor voluntarily, you can't get them there. And so
Exactly.
you can't prepare the application.
Absolutely. And there is no way to force someone to get medical treatment. There are many challenges, because I've had a situation where a wife came into me and she said she knew that her husband was no longer operating at the level he should. He was spending all their money, and these were elderly people, so you know they're on a fixed income, and they had an interest in a company, and she said the stock would go missing as well, and there was just no way to control him. She tried to urge him to see the doctor, and he wouldn't go. And I really had no solution for her in that situation. But the next part I'll deal with now is the Mental Health Act itself. Okay? There are many other things I could say about the Mental Capacity Act, but I think it's for the committee to start the process of looking into what other, and you may have already done this, looking into what other solutions that countries such as the UK, Canada, Australia have found, and seeing whether any of those can be adopted in Jamaica. Now, the Mental Health Act, the first thing I don't like is the name of it, but that's an aside. The act itself, as far as legislations go, is not that old, but the way in which it is structured presents challenges for practitioners who are trying to get legal guardians or other competent persons to be appointed to care for people who have mental health issues, which we define under the Act as mental disorder. And it's a substantial disorder of thought, perception, orientation, or memory, which grossly impairs a person's behavior, judgment, capacity to recognize reality, or ability to meet the demands of life, which renders a person to be of unsound mind, or mental retardation, where such a condition is associated with abnormally aggressive or seriously irresponsible behavior. Now, if someone has mental disorder, as defined there, we can look to the Mental Health Act, because someone who is suffering from a mental disorder is a patient, and the Mental Health Act is designed to deal with patients. To the next slide, though. Here is the problem. How do you properly define who is a patient? Now, there are cases that have gone before the Supreme Court in which there are gone as far as the Court of Appeal to determine whether someone has mental disorder, because you do need that medical report that is going to properly diagnose the condition. And you also need factual evidence to confirm to the satisfaction of the court that the person is no longer capable of managing his or her own affairs. That's easier said than done, because there are, as Chairman said, sometimes you can't get the person to go to the doctor. And even if the person could go to the doctor, many people can't afford it. And the next aspect of the Act that's important is the fact that once someone has a mental disorder and could be defined to be a patient under the Act, then the nearest relative of that patient can apply to the court to be appointed to care for that patient's needs. Let's look at the next slide. Who is a relative? Because it starts, there's a hierarchy, of course. And the starting point, the starting point is husband or wife. That's the first person in line to be appointed as the guardian or the person who can take charge of a patient's affairs. So it goes through husband or wife, son or daughter, father, mother, brother, sister, grandparent, grandchild, uncle or aunt, nephew or niece. You already see that cousins aren't included, right? That's a big gap sometimes for people.
Nor in-laws.
And no in-laws, for sure. They are only blood relatives here.
Relatives, yeah.
Only blood relatives. And the most critical aspect of all of this is that part of the slide to the right, where it says the nearest relative has to be ordinarily resident in Jamaica to apply under the Mental Health Act to take charge of the affairs of a patient. I can't tell you how many times that's been the critical point at which we have to abandon thoughts about making an application. And this is because the Act specifically says if the nearest relative resides overseas, he's ascertained as if he's dead. And when I say he, I also include she. So the Act gives you no wiggle room. If your husband or wife lives outside of Jamaica and you have a mental disorder, your husband or wife can't apply to be your guardian under the Mental Health Act. And that creates more challenges than any other one, because when you've gone through the list of near relatives and you've got to nephew or niece and there's no one there, you know what the Act says, Chairman? I don't know if you have ever encountered this, but it says that the applicant who could properly proceed to court is the Attorney General for Jamaica. And I have personally tried to get the Attorney General for Jamaica to intervene in a situation where there is no near relative in Jamaica. I have not succeeded. So we need to broaden the category of persons who might be able to step in to care for the needs of mental patients.
Sorry, can I ask a question here? I mean, what would be counsel this broaden expansion include? And just clarify for me the part that speaks, so he is ascertained as if dead.
So we treat you as if you are dead. We do not even consider you as a potential applicant.
Okay.
It's as if you do not exist at all. And because of how the Jamaican family is structured, I think it would be reasonable to include cousins, at least, and to also seriously consider whether the nearest relative needs to be physically present in Jamaica. I think it's worthwhile considering, because when you look at the Mental Health Act as it's currently structured, it really is geared towards making financial decisions. And in most instances where I've run into that roadblock, it's because the person who provides finances and makes the financial decisions is actually the one who lives overseas. So they're already making those decisions. So is there room to consider them being appointed under the Act to be the guardian of the patient?
And so we're still limiting it to what you would regard as blood-related relatives?
Well, I would have to look to see if there is any scope for in-laws to be included, but yes, for now, I think it would be reasonable to limit it to blood relatives.
All right, thank you for that, Coach.
I'm going to ask Fraser Binns to ask her question, but just before she asks her question, you know, we recently secured an order for guardianship in a case where the person who is appointed guardian is not a blood relative, but it was done in circumstances where the only living relative resided in the UK and joined the application. But the fact is that there are those older persons who have no relatives in Jamaica and who may have a neighbor or a church friend who really operates like family but is not blood.
So there could be a joint application that could include that relative overseas and someone else on the ground. It's possible. But to your point, and before Mrs. Fraser-Binns comments, I encountered a situation where it was impossible to ascertain the mental capacity of the person who became ill, because he was hale and hearty, active, and he ended up having a stroke and a heart attack. And he was therefore locked in. So there was no way for a doctor to medically determine whether he would fit in the definition of patient under the Mental Health Act. But thankfully, under the Supreme Court Act, the court has what we call inherent jurisdiction over elderly persons, as they do over children. And so what I was able to do was invoke the inherent jurisdiction of the court to ask that a guardian be appointed for the person, because I could have the court accept that the person was a vulnerable adult. So it's those kinds of, what would you call, outside the box thinking that has to be done, because we recognize that the Mental Health Act only deals with situations where there is mental incompetence that can be diagnosed and doesn't deal with physical incapacity. Mrs. Fraser-Binns?
Thank you, Chairman. Thank you, Chairman. And I know that Ms. McGregor has not finished her presentation, but I'm sitting and I'm listening and I'm really smiling because she's touching on the issues that are of critical importance for us as a committee. And speaking about the Mental Health Act, one of the things that struck me, and I have said this over and over about the need to amend the Mental Health Act, is this particular provision that speaks about the person must be ordinary resident in Jamaica. And Chairman, if there's any recommendation we can take from Ms. McGregor's presentation today, is for that particular provision to be amended, because in so many instances, this is the hurdle that a lot of attorneys cannot cross, because the person who is best able to give the care and to
Senator Fraser-Binns, have we lost you?
oversee the affairs of the person simply does not live in. Cousins or neighbors call when that particular elderly person needs medical attention, if there's anything that's wrong with that person. So I really just wanted to add my own support to the recommendation by Ms. McGregor, particularly in terms of doing away with this provision that the near relative needs to be an ordinary resident in Jamaica.
Thank you for that. Because as long as you're a practitioner in Jamaica in this area, you're likely to have encountered that problem. But what I did in this presentation was to point out some of the challenges. And I touched on one just now, where the person became locked in. And thankfully, the court was able to find a solution. But here's another one that I encountered, and this is slide 33, if Mrs. Beckford could get to it. So in this situation, thankfully, there was still both a husband and a wife. They had been married for over 50 years. They operated a business together, and the situation is that the husband became ill and he was unable to walk. And the family placed him in a nursing home. And because the wife, although she was still active, was incapable of caring for him. But shortly after the husband went to the nursing home, the wife was diagnosed with dementia, and she was incapable of managing her own affairs. But if you remember, I told you there's a hierarchy. The nearest relative of the wife would be the husband, the nearest relative of the husband would be the wife. And there is no provision under the Act that would have disqualified the husband from maintaining his status as the nearest relative. But now you have husband physically incapacitated, wife mentally incapacitated. Neither could care for the other. The child came to me, and so I had to take care of two separate applications, two separate issues. The first one was that because the husband was first in line, I had to satisfy the court that although he was mentally competent, he was physically incompetent. And then, so that I could clear him off as the nearest relative. And then I moved on to the application to appoint the child as guardian of the wife. These are challenges that you don't necessarily anticipate, but when you encounter them, you realize that the law is structured in a way that lends itself to an easy solution.
Thank you. Senator Floyd Morris has a question or comment.
No, thank you very much, Madam Chair. I wanted to make an earlier intervention, but I had to consult on something. Just to say that the Committee on the Rights of Persons with Disabilities has recommended in its concluding observations on Jamaica's report to the CRPD committee that the Mental Health Act be reviewed, and some of the issues that are being deliberated here are some of the issues that the committee is concerned about. And I would like, Madam Chair, for you to, in time, make reference to the CRPD, the Convention on the Rights of Persons with Disabilities that Jamaica signed and ratified, Article 12, which deals with the issue of legal capacity for persons with disabilities, because the conditions that are being discussed here are all categorized as disabling conditions. So they are pertinent to the CRPD is pertinent to it. And so I would commend that at some point in time, we'll look at what this International Human Rights Treaty that we have signed and ratified says in terms of legal capacity for persons with disabilities. That's my intervention for now, Madam Chair.
Mm-hmm. Thank you, Senator Morris.
Mm-hmm. And of course, if I may comment on what Senator Morris said, what we have to do then is ensure that there is complementary legislation, because there are some times when one legislation could be more effective by referring to another, and we lose the opportunity to do that. So I certainly appreciate his intervention from that standpoint.
We have one other intervention from Mrs. McCoy Davis of the National Council, Chair of the Council. Go ahead, Chair.
Good afternoon, Senator. All right, so Council, thank you so much for your presentation so far. I wanted to ask a question as far as the older adults are concerned with regards to us having a growing elder orphan population, meaning older adults are aging alone with no other family members around, how do we treat it in this situation where, you know, technically there are no other family members around and there are other persons who are intervening, maybe godchildren or other support system in the community? How do we treat with it? Thanks.
I think it begs the question, just how broadly can we define that category of persons who we would say is entitled to apply to the courts to be appointed as a guardian? Because of course we have to have effective guardrails, right? We have to also do our research to ensure that we are actually identifying where the gaps are, so that it's not so wide that it's uncontrollable, but it is wide enough to address the concerns that actually arise. So I know we mentioned neighbor, but I think there is still some necessity to ensure that if we are appointing someone who is not a blood or the primary applicant is not a blood relative, that we also try to find a secondary applicant, or to design it in a way so that there is a committee of persons who are answerable to the needs of the elderly person. And in that way, we will be able to better safeguard their interests. I hope that helps.
Yes, Counsel, thank you so much.
You're welcome. And there was another point I wanted to raise, and this is because it's emerged so often over the years. We have, as you know, we have a large diaspora, and many of the Jamaicans who went to live overseas as adults, they either owned property in Jamaica at some point in time, or they subsequently, they owned them before they left Jamaica or subsequently acquired them. And unfortunately, when they develop mental health issues overseas and their guardians are appointed there, there is no specific path towards ensuring that the court orders that are made overseas to appoint those guardians are recognized in Jamaica. And Chairman, tell me if you understand the problem. What has happened to me over the years is that I've been called upon by clients who say, my mother is living in New York. She's in a nursing home. I've been appointed as her legal guardian. She owns a house in Kingston, and we need the money from the sale of that house to continue to provide for her care in New York. Problem is, the Jamaican court does not recognize automatically the court order that was made overseas. And without the court order, there is no person who has lawful authority to dispose of the property in question. What we've had to do is to try to rely on the provisions of the Supreme Court Act and to rely on international law principles. For those who are familiar with the term comity, to say that the court order was made in a court of competent jurisdiction, and because the person in question, the patient, has significant ties to Jamaica, is a Jamaican national, we've been able to get a court order in those cases. But I'm sharing with you another common problem that we've seen emerge over the years, I can't say exactly what the solution is, but I would like for you to bear it in mind. And I've also encountered situations where Jamaicans have gone overseas for visits, and then so they are not ordinarily resident in the United States or Canada or elsewhere. Jamaica is home, but they're overseas on a visit, and develop a medical condition that, such as a stroke or something like that, that renders them incapable of managing their own affairs, only to be left in a situation where there are assets in Jamaica or other needs to take care of business in Jamaica, and there's no one competent to take care of their needs. So that's yet another problem that I'm not sure if it's for this committee, but it's also relevant for you to bear in mind.
Does that evolve then, council, into a proposal that, like we do with probate orders overseas, where we have a process of resealing probate here, that an order for guardianship be treated in a similar fashion?
It could definitely be the case, because you know what's true? It would perhaps, however, involve treaties, and we would have to look to see what treaties might exist in that regard, because we certainly have treaty provisions in place to recognize maintenance orders when it comes to children in some instances. So yes, I think that would be great, because these are the types of orders that you need to have recognized quickly enough so that effective steps can be taken to take care of the needs of the patient in question. So I had created what I called a wish list, arising from the experiences I've had, and so let's go first to slide 35 and why I said we should be mad. No, one slide back, I think, the previous slide. So Albert Einstein is often credited for saying that insanity is doing the same thing over and over again and expecting different results. With each new client with a need to protect the interests of a vulnerable adult or to appoint a guardian for someone who is diagnosed with a mental disorder, we seem to open a mystery box because there are no clear guidelines. And the cycle continues unabated, and it is simply unacceptable in my view. The underlying issues are not new, but new problems will continue to confront us because people get older every day, and other countries have helped their citizens to find solutions. We need to do the same. Here's my wish list. Number 1, we need to enact legislation to govern powers of attorney. We need to eliminate the guesswork, and any such legislation must overcome the obstacles concerning supervening mental incapacity by including lasting powers of attorney and include provisions for advanced care directives such as do not resuscitate. We should also consider whether there should be a designated registry for powers of attorney with the power to investigate their use and safeguard the interests of the donors from abuse. Number 2, and everybody has said this, so we know 10,000 Romans don't lie, 10,000 Jamaicans don't lie. review the provisions of the Mental Health Act, look at the categories of relatives who may apply for guardianship and the scope of the powers of the guardian over the person and the estate of the patient. We can split them. We can have financial decisions separate from healthcare decisions. And questions such as why cousins or step relatives are excluded and whether to include anyone else who is not a relative with whom the patient resides and has been living for 5 years could be answered. So those are possible solutions. We also need subsidiary legislation to outline the criteria for assessing mental capacity, the scope and duration of guardianship orders, reporting obligations under the orders, because you can have measures in place for periodic reports to be made to the court, and how we change the patient's nearest relative without there being major hiccups or long, lengthy periods when one guardian ceases to act and a new one needs to come on board. We also need we need to be able to discharge guardians easily, because if they are not doing their work, we need to be able to move them out. And there needs to be further clarity as to the steps the appropriate state agent should take when a patient has no relatives, and perhaps the need for patients to have a mental health advocate. Third one, we need to consider whether there is room to empower the actual financial providers and decision makers. So in reviewing the Mental Health Act, we need to address the often recurring challenge where the actual decision maker and financial provider for a patient resides overseas and is automatically excluded as a candidate to be the legal guardian. Is there room to consider appointing even a temporary guardian or an alternate or a proxy? We need to look beyond what's written there. And the fourth one, which is where you had mentioned, Chairman, cross-border recognition of powers of attorney and guardianship orders, because powers of attorney are not automatically recognized in Jamaica either. A power of attorney or guardianship order recorded outside of Jamaica, not automatically recognized. So a new power of attorney specific to Jamaica or a court application for a ruling on enforceability are the only two available options. So we have examples of treaties that support cross-border recognition of power of attorney. The Hague Convention on the International Protection of Adults, and that was concluded by the Hague Conference on Private International Law in 2000. Here's my conclusion. In relation to powers of attorney, there is desperate need for the common law principles that govern them to become codified, because codification of the law helps to create a uniform source of law that is easily accessible to professionals and laypersons. There is an obvious need to ensure that, depending on the wishes of a donor, a power of attorney will not automatically lapse when the donor has supervening mental incapacity. Lasting powers of attorney provide a useful solution. So in relation, and finally, in relation to the Mental Health Act, review it, update it. Where necessary, we need to remove the guesswork as to the procedure to be adopted to secure guardianship orders by enacting subsidiary legislation or rules of court. Madam Chairman, members of the committee, thank you for the opportunity to speak with you today.
Thank you, Council, and we are very gratified that you were able to come, and colleagues, I will just indicate, Council got relatively short notice. So I really thank her for this very in-depth presentation. And I see the hands going up. I'm going to first my colleagues on this one. Just to ask you, Council, if you could opine on the structure of a living will as opposed to a power of attorney, and whether or not that has any value in how we treat with our older persons who become incapacitated, whether physically or mentally.
So living wills are something that I had researched some years ago. I'm just looking for some material here. I think there is room for them. There is tremendous scope for us to consider their utility. But my view is that these are not substitutes for what we are talking about here.
Could you just explain what a living will is for the benefit of the public?
Sure. Do you remember a case some years ago involving a lady called Terry Shivo? So she was married and she was plunged into a vegetative state after suffering a heart attack in 1990. And she remained on artificial life support for 15 years until March 18, 2005, when a Florida Circuit Court ordered her feeding tube removed. The big debate that brought it to the attention of the media was that her parents did not want the tube to be removed, but her husband did. And the question that really bothered everyone was, what would Terry Shivo have wanted for herself? So what a living will does is that it's signed by someone at a time when they are mentally competent and capable of making decisions, and it stipulates what that person would want to have happen to him or her in terms of any artificial life-sustaining measures, such as feeding tubes or oxygen tubes. And so it's called a living will, but it truly is not a will in the sense that it makes decisions prior to someone's death. But so it would help your family to know whether you want to be resuscitated or to be on feeding tubes or to be just lying there lifeless. And so there is room for it. And I think it would be very helpful, because one of the most painful decisions anyone could ever make is to determine whether or not to pull the plug when you don't know if your relative would have wanted to remain in that state or not. So yes, Chairman, living wills should be discussed.
And I just want to say, for the benefit of all who are listening too, that the practical import of this, of course, if I'm a person who has who has developed a condition that has me in a coma on a feeding tube, personally speaking, I would not want my family to have me on that feeding tube for months and months, in circumstances where their financial capacity to support my care is being depleted, with very little hope of me ever being able to come off that feeding tube. So there's some practical things that are impacted. But let me ask.
Moral, right?
Yes, indeed. Senator Gill, I think your hand was first, and then Senator Longmore.
Thank you, Chair. Councillor, I really appreciate this presentation in terms of the level of awareness. I wasn't aware that we never had any specific legislation dealing with this awesome responsibility entrusted in powers of attorney, against the misuse or abuse. I have 3 questions in terms of the registry you spoke about. How does that registry work when the power of attorney can be one of voluntarism? The second one has to deal with, you may have disputes between family members or caregivers over the authority and abuse of power of attorney. And how do you treat with those kinds of disputes in your experience? And the third one is, the revocation of a power of attorney, because you give this awesome responsibility to a power of attorney and they take it for life. But in the event of disputes between family members and powers of attorney, how does that kind of revocation takes place?
Okay, so I don't have perfect responses to these questions, but thanks for your comments. Based on my research, when it comes to the registry, what I looked at was the situation in the UK. And so much like, I know back in the day, like the FSC, for example, or an independent regulatory body, that's what it contemplates, so that the registry would be set up to receive all of these powers of attorney. There would still be need for court intervention sometimes if there are disputes. The question about revocation could be built into the legislation to say that there are certain triggers for it. But even independently of that, what my research showed was that there was an independent advocate who would look into cases of abuse and determine whether there was necessity for revocation. So I think at the heart of it would be the need to put in place measures to ensure effective monitoring of how the powers of attorney are being relied on. And in that way, if we are monitoring closely enough, then we would be able to intervene and in a timely manner to ensure that there is no abuse.
Thank you.
You're welcome.
Thank you, Cohen. Thank you, Chair.
Senator Longmore.
Thank you, Chair. And again, like I said, I'm kind of in the middle of my errand, so I'm not able to put my camera on. Suffice to say, Mr. McGregor, thank you so much. My earlier comment holds more fulsomely, I think. You mentioned 1 or 2 times in your personal practice where you had to somewhat think out of the box and do legal gymnastics to try to come to some resolution. I am again indicating I kind of have the challenge where I do have that technical awareness and the medical and specifically psychiatric awareness of the issues that are afoot here, to now also balance and try to create the legislative approach. I repeat to the committee, and I think we are hearing it, some of the questions that Senator Gale just asked. It is such a huge task with the inadequacies of the Mental Health Act. Even what the definition that you brought to our fore is so outdated and so out of sync with what is current in our diagnostic and also our advocacy for our clients. It is such a huge task that there is no simple solution to this fix unless we have a significant overhaul of the Mental Health Act and specifically dealing with the stages of cognitive decline and the stages of incapacity. I don't know if it is something that we would consider where there's a special presentation on this, but at the same time, it is almost futile to make those recommendations here in this Elderly Care Act without the necessary changes that would have to happen in the Mental Health Act and perhaps some other pieces of legislation. So I just want to underscore how much I appreciate your presentation, Ms. McGregor, but also the magnitude of how much of a fix needs to be had to address this very significant situation that affects the elderly. Thank you, Chair.
Thank you, Senator Longmore. And Senator Longmore, although the Mental Health Act arguably might be outside of the scope of the committee, and I think it can be argued it may very well be within the committee's remit to comment on it. Nothing stops us from putting in our report that recommendation and even outlining the ways in which we think it would need to be amended.
Because, Chairman, it's always best for us when we are introducing either new legislation or looking to make amendments that we look broadly enough so that we are not left with a kind of hodgepodge, piecemeal approach to something that has such significant implications for a significant portion of the population. So.
Well noted, Council.
Yes.
Are there any other questions to Ms. McGregor? I do have one last question, and that is, we have discussed in this committee various approaches to what in essence would be almost like a regulator, someone who has the responsibility for advocacy, who can step in and act on behalf of or in the interest of, similar to the Office of the Children's Advocate. Can you opine a little bit on that, and how would these powers of attorney with this kind of change be managed by an office like that, or would that be the appropriate place to manage it?
I had touched on it earlier when looking at the approach in England. I'm just looking for that slide because what they did there was to establish a specific, that's where Senator Gale came up with the comments concerning the registry, because what they did there was to establish a registry, establish a specific office for dealing with the mental health, with the powers of attorney. I'm finding it here under their Mental Capacity Act. So what they did there was to establish the Office of the Public Guardian, which, as you said, seems to be akin to the Office of the Children's Advocate. And that is where the powers of attorney would be registered. And the Office of the Public Guardian would provide legal advice to donees where necessary, and could investigate allegations of abuse, and also be the advocate on behalf of the, let's call the person the patient, for want of a better term. So there are comparable experiences outside of Jamaica that we could investigate more thoroughly to see whether they are working, or the extent to which we might be able to adopt some, if not all, of the measures they have put in place. and create our own that is suitable to our own needs.
Very well. Thank you. I see Senator Professor Morris.
Madam Chair.
Go ahead, Senator
Madam Chair.
Morris. Go ahead,
Yes,
Senator
you know, I want to join with my colleague Kavan to really commend the presenter on her excellent presentation. And I think, you know, Madam Chair, this committee has been blessed with some excellent presenters who do have a passion for our senior citizens. And I mean, we have to make sure that we come up with the best solution or fit where this legislation is concerned. And I just want to say that, you know, as I listen to the presentation, we have to make sure that we do some checks, some cross-references of the different legislation, and to make sure that they are, you know, in accordance with best human rights practices across the world. And the presenter did mention some jurisdictions that are similar to ours in Canada, the UK, New Zealand, and Australia that would have some form of legislation to deal with these situations. And so, you know, when we are doing our final documentation, this is something that we have to make sure that the law that we craft is anchored in the human rights approach that will serve to protect our senior citizens, especially those with disabling conditions.
Thank you, Professor Morris.
Yes, thank you, Senator Morris. Okay, so have we concluded all the questions?
Seems that way.
Seems we have. Council, I want to thank you again on behalf of the committee for this excellent presentation and for the work you put in to take us to another level yet today. We have some hunkering down to do for sure, but you have outlined for us very well the kinds of legislative provisions that need to be put in place. And so thank you, thank you, thank you on behalf of this committee and the Jamaican people at large.
You are welcome, Senator Golden Campbell, and I'm always happy to serve.
And don't be surprised, I've said this to most of our presenters, we may come back to you behind the scenes as we prepare our report.
I'm open to it.
Very well.
Thank you. All right.
All right, members. We have concluded this last presentation. I see on my agenda review of the matrix of recommendations. Madam Clerk, were these recommendations distributed to the committee members?
Sure, they were sent out prior to the meeting.
They were. All right. Have members had a chance to review them?
Chair, this is Nadine Wilkins.
Yes.
Could we find out exactly when were they sent out? I seem to have missed that email.
This afternoon.
I'm sorry, which day?
This afternoon.
Oh, I see. Okay, because I was looking this morning. Okay.
Fine. All right. So on that note, then, Madam Clerk, we have a date set for a week from now, correct?
The 26th of June.
Thank you. Members, I'm going to ask you to do some homework with all the competing interests that you have, I know. everyone has a full plate, but please to review the matrix so that we can go through them with some efficiency. And I imagine that it will have to be updated with the presentation we have heard today as well. But you can at least start with what has already been delivered to us. Given it was delivered today, I don't expect members to be ready to deliberate on it. But on the 26th of June, I will very much expect members to be ready to have those discussions. And so on that note, if there's no other business.
Chairman, if I may?
Senator Fraser-Binns.
Yes, Chairman. I wish to inquire what is the time on the 26th, whether it's an afternoon meeting or morning meeting?
2 p.m. 2 p.m.
Okay. Perhaps, Chairman, we could do a round robin amongst the members to find out if that time is convenient for all the members.
I think we had agreed that date and time at our last meeting, you know.
Yes, Chairman.
At 2 p.m., sir?
Yes, at the last meeting.
We had agreed that date and time at our last meeting.
We had proposed today and next week at the same time.
Right.
At our last meeting.
I must have missed that, Chairman. Not a problem.
Yes.
Thank you, Chair.
Members, I will take a look at whether that meeting is better had virtually or in person, with the usual provision that if it is in person, it will likely be a hybrid meeting. But it may also be useful. That meeting might be quite appropriate to have virtually as well. So I'll have some discussions with members on that, and we'll see the appropriate notice in due course. All right. There being no other business, and we do know the date of the next meeting is 2 p.m., Thursday, the 26th of June. Might I now have a motion for the adjournment?
I am moving to.
Thank you, Senator Gale. And seconded?
Second, Chairman.
Thank you, Senator Fraser-Binns. Thank you again to the parliamentary team, legal reform, and all those who have put in the work to get us to this point. I'll see you all next week, God willing.
Recording.
We want a piece for Jamaica. Yeah. Yo, what are you? Oh man, none of that. Yo, no, brother, no, man. Mash up that, man. You see you ever play ref? Dirty game, man. But I look a bad game. No, I said, person come from, brother, I want to live good, man. I want to live good, brethren. No shake hand, I can play a little bad, brethren. Really have to shake hand? Yeah, man, and no badness, brethren. Just live good, man. Come together, I make the violence done. What a flow, what a flow. What a flow, what a flow. Come on. What a flow, what a flow. What a flow, what a flow. The water put it just like a freestyle. The life blood flowing mile by mile. It's legacy, a beat that don't stop like Bob Marley say. One love on top. The sewage water out of sight, but it's always wrong, don't lose the light. From factories and wells so deep, cause one goes and fish they weep. Bring water for the garden, keep it green. Save the cash and the earth gets clean. We use the water with a mindful mind. It's out of sight but never far behind. In nature, the answers always flow. Like water running pure, the cycle grows. It renews itself, same drop, same beat. It's all good, man, you got the heat. Water flow, water flow. No clean water, no vibes we grow. Protect our water, protect our future.
Time to go.
The budget is made up of expenditure and revenue estimates that are tabled in the House of Representatives at the same time by the Minister of Finance and the Public Service. The expenditure is the projected cost to cover the country's loans to public bodies, public debt, non-wage expenditure, wages, salaries, and capital for the financial year. The revenue is the total sum of money that the government will collect or raise to fund its expenditure for the financial year. The major revenue items include taxation, non-tax and capital revenue, grants, capital development fund, and loan receipts. The national budget is everybody's business because it impacts every Jamaican. Visit mof.gov.jm for more information.
Motorists, as Minister of Justice, I appeal to you, obey the road code, pay your ticket on time, and only go to court if the ticket is being contested. Close to 80% of matters coming to the parish courts are for traffic breaches. Let's work together to make our roads safe and ease the burden on our courts.